we lost him, and it is believed, according to reports, that he succumbed to COVID-19. That is just over the weekend.
Well, just before even actually get to that, I just remembered the two reports that I read about the Chiwetere massacre infant of the March 2000. There was one that was done by the Makerere Religious Department of Monsignor Narcisio, and he revealed lots of things in there. That one of the things that actually drove Chiwetere's followers and believers of the restoration of the Ten Commandments of God is that their cult leaders, Joseph Chiwetere, Claudenio Mwelinde, Father Katadi Babo, and Father Pauli Kazire, they had what they called apparitions, the apparition things, where somebody now, you know, somebody could come and say, I have just seen or met the Virgin Mary, and she's crying, she's bitter about what is possibly happening in the country, in the church. She's actually crying blood tears, she's crying all these things, and quite a number of those. Then, of course, a report that was done by the Human Rights Commission, which is also another very good report to read, and maybe there are reports about that. So it was many of those things that informed the belief system of these cults, and that's how they ended up doing all those bad things. But then on another very sad note, the death of the Ikumbanya, John Chrysostom Wayabide, also comes, of course, to us. It's a very sad incident. He was my personal friend. He was my personal friend. I've personally known Ikumbanya for over 10 years. Because I met him.
He was a pastor? That's
yes, he was still a pastor even now.
Oh, I thought after being thrown he
continued these pastoral duties.
Okay.
He had actually now been ordained as a bishop because he had quite a number of churches, yes. And he had also given up his home church to another resident pastor because of this nature of work and duties that he was doing. I attended his coronation when they were coronating him on that particular day, and of course the leaders who came, the other cultural leaders. That time, I think the Isaba Ruli was the head of you know, they have an organization that brings together all the cultural leaders in this country. And they have their rotational leadership of who heads that association. So that time it was the Sabaruli of Buruli who was there, and of course quite a number of. I was happy when he became. I last spoke to him on. I spoke to him. I think a few days to nomination. A few days to the nominations, the presidential nominations that we had last year. That's the time I actually spoke to him. I hosted one of his brothers in studios here, Ndugu Mauku, the general secretary of HTS Union. So and I didn't know. So when he says his name is Mauku, because I know the geography, the political geography of Uganda, I wanted to find out where he comes from, and he said, but I am a younger brother to Kumbanya. And he said, no, he's my friend. I actually called him and we spoke, and I told him, I've just been hosting your brother here. And he said, yes, I watched the program, so he was my friend. It's very bad and sad. I talked to his son last evening, Geoffrey Wayabide, and he said, yes, Mzee has died to COVID. He succumbed to COVID. And so, as a family, they're not denying that. It's COVID.
Actually, on Saturday, I spoke to the brother, Moses Mauku. I was supposed to have a show with him on Star FM. And he tells me, Robert, we are fidgeting to get ICU. We are from Entebbe. Now we've come to Nakasero Sam Hospital. And I think they failed to get ICU. Then he said the administrative issues. So I asked him, but what is the Ikumbanya suffering from? He told me, it is COVID-19.
The family was
yeah, so I just told him, comrade, we can... We said, well, let's first get the bed here, and then we come, we do the show. But of course, I had had the enemy. I told him, no, the best thing is we can postpone the show. But it's a sad note. We stand with the kingdom, that is the Bagwere.
The Bagwere.
We stand with you. We pray for you that the good Lord may strengthen you
at this trying moment. He'll be buried, I think, after 2 weeks.
Yeah, after 2 weeks,
but yes. in Bagwere. That's tentative from his son. I don't know whether it's him who decides finally. But that was a telephone conversation I had with him in the evening. And so... Well, may his soul rest in peace until we meet in eternity. Wherever he has gone, Yeah.
God
he
be
can't
with
come
him
back to us
till we meet again.
where he's going.
Well, it's time. We had so much to discuss, but now just have to enter into the topic of the day, which is presidential election petitions and their significance to democracy. We must remember that this is not the first time that after an election we are having court settling issues. This is the fourth time actually that Uganda's election ends in an election petition. But also over 50 countries in Africa have had elections and they have ended in courts. However, we've only seen a nullification in 2 countries. That is in Malawi, that was last year, we saw it, 2020. In Kenya, that was in 2017, where we saw court annulled an election. So we want to assess, we want to look at this. Is this just formality that after an election, because there's a constitutional provision, people go to court? Then after, what happens in court? Do we really see any significance? This is what you're going to be discussing, I and Jagenda, not as experts, because we're not legal experts at this, but also as people who follow the politics of Uganda and Africa and the rest of the world. Jagenda, Uganda, this is not the first time. 4th time, we've had even some recommendations, but every petition, Mosokiza Besije versus Yoweri Kaguta Museveni and the Electoral Commission, recommendations, even during Amama Mbabazi's recommendation, and I was reading one of the retired judges who said that if we had gone by these recommendations, maybe we would have averted what is happening. Justice Kanehamba saying, but because sometimes these are taken lightly, so is this for formality? Do they have any significance on our democracy?
Yes, they do have a lot of significance on our democracies. Now, you're talking about the previous elections or the previous court rulings on the continent of Africa, the 2021 in Malawi. Now, the Malawi case is actually quite a little different because when Mutharika's election was nullified, it was actually nullified, I think, after about 2 years and 8 months or something. He had formed a government, he was moving on and everything. Now, what happened in Malawi was when court nullified the election, first of all, their petitions do not go to the Supreme Court, they go to the High Court. Now, High Courts normally have what they call original jurisdiction. So, of course, when they go to the High Court nullified the election, and Mutharika could appeal if you wanted to. Now, that's a very unique situation where you have a court nullifying a presidential election, then you actually go and appeal. Now, but he
chose not to.
He chose not to, of course. To us, it works differently. The levels where you can actually appeal is at a parliament level, where you get to High Court, and after Court of Appeal, you stop there. You do not go beyond the first appellate court. Now, the Malawi case was when, you see the situation in Malawi was actually very different. That the people that took Mutharika to court, 2 were actually his vice presidents. 2 were his vice presidents because they also participated in that particular election. Now, they go to court, you have a vice president, you're running a government together, but the vice president is actually in court against you saying it was a fraudulent election. So, of course, court nullified it, and that's how Lazarus Chakwera comes back from that re-election. Now, when you go to Kenya, Kenya had an issue in 2007-2008. When they had that December election of Samuel Chivuta, who was the chairperson of the Kenya National Electoral Commission at that time, I think it was called KNEC. When the election ended, they asked the chairperson of the Electoral Commission that was won the election. And he first of all said, at first he didn't know who had actually won the election. Now, because he didn't know who had won the election, then they told him, announce Mwai Kibaki. So he announces Mwai Kibaki, and now the Raila Odinga team, the ODM people say, we have also won this election. So it became a contest. Now, the other bit where actually you saw that post-election violence that ensued in Kenya after the 2017 election was because there was no room for court negotiation. There was no room for court arbitration. When Samuel Chivuta announced that the winner of the election was actually Mwai Kibaki. Yes, then the other day he had to be sworn in that quickly. You remember people used to make fun here and Yitamubwangu Ngala is Kibaki. You don't have to waste time when you're swearing in Kibaki. It is pap, then you know you go. So they decided that's why they actually had that problem, because there was no window for them to sort issues. So of course, you saw what happened and what ensued. And later in 2010, they rewrote their constitution. Now, when they adopted and promulgated this new constitution, they put in that now, remember, they understudied the constitution of Uganda. And when you look at the constitution of Kenya, similar, there are clauses that are actually very similar to the Ugandan. And they also accept that they understudied Uganda's constitution. That's what they benchmarked. Now, what they did is they tested it in 2013 during the time of Chief Justice William Mtunji. After that election, which you again saw, the election of Uhuru Kenyatta and Raila Odinga, the first time in 2013 when they had it, still Raila Odinga went to court. Justice Mtunji, William Mtunji, of course, ruled in favor of the winning candidate, Muigai Kenyatta. Then they tried it out in 2017, and now Justice David Maraga actually nullified the election. Now, the issues that were in that election were also very important, because when you look at Justice Maraga's ruling, it is what has now made and paved way for the BBI today. The BBI, the Building the Bridges initiative that I actually have today, because the idea of having a winner takes all, exactly, is what causes all these issues. At first, you could think that Justice Maraga was actually not politically conscious about his decision and what he was actually doing. But when you get back to reading what is done, you can actually get some very good sense. The unfortunate
bit is that even when they had another election, it was more worse than the previous, where we saw a couple of counties did not even vote. There's so much boycott. The voter turnout was so low. It was more in favor of the incumbent.
No, exactly, not actually in favor of the incumbent, because when you look at the first election of the first election before the nullification, the margins that Uhuru Kenyatta actually won with are the same margins that he won with. Now it was just like saying, let's redo the election, and the things happen. Even if we decided to redo our election here, you wouldn't be surprised that the outcome would still be the same, because Raila Odinga boycotted the election. The day he said he's bowing out of the election, court ruled in favor of another candidate who had actually gone to court, Ukuro Court, who said, is it now an affair of just the two principals, Raila Odinga and Uhuru Kenyatta? Because this was not a rerun. This was a redoing the entire process. Now, that meant that everybody who had participated in that election was eligible to actually come back. Because when you say the election was fraudulent, when you say the election had issues, then it could have had a problem with just only you and him, yet all of us participated in that same process. So when they did it, courts just allowed them to go and they redo. Now, Odinga's problem was, when we go back to redo the election, shall we have the same commission of Wafula Chebukati, the IEBC, doing the same thing? Now, they were already faulting the commission for failing to transmit results to the Bomas of Kenya, their National Tally Center, and quite a number of things. Now, these things were not in Maraga's ruling, because these are not the things that they requested for or they asked for. Court. Exactly. So, the issues there were, you're asking us to redo the election, but are we redoing the election with the same people? Are the same people who messed this election going to the same? So now this is exactly what happens. Now, I don't know whether our lawyers here, our seasoned lawyers and the experts here have actually learned from many of these. Now, when it comes back to the Ugandan scenario, and of course, also before you go to Uganda, also understanding that there's also a difference in terms of constitutional law in some of these countries and presidential acts. Some countries you can even petition after a new government has been created. Others, for Uganda's case, it's very different, because when you look at a country like Ghana, that even you have elections are done, a government is elected, a government is formed, a president is sworn in, then again you still have that time to petition. Whereas for us it is simple. We first sort this mess before the president is sworn in. Exactly. It's actually a very unique situation in Ghana, because in Ghana, I was reading Ghana's case and I was like, yes, how would you cabinet is set, the president is ruling, government is running, parliament is on. Yeah, it's a different scenario. You know, when people talk about certain things in Ghana, especially because we want to look at Ghana and portray Ghana as the model of African democracy, but Ghana has also some unique things that you look at and say, how could this happen? When you get back to 2012, when you had that, I think it was in 2012, yes, when you had that petition presidential petition that went to court. Now they were in court. But at the same time, the president-elect was being sworn in and you know, taking over government and making government, forming government. Now, it's the same thing now that you had Nana Akufo-Addo of NPP winning the election. With the margin of, I think, the percentage margin, I think, is just about 3%, because one had, I think, 51 and the other had about 47%.
47, 51.
Exactly.
Yeah.
So now you find that John Dramani Mahama says, no, we are contesting this election. Now, the other side, Nana Akufo-Dankwa also says, yes, we won. Now, he's already making government and forming government and carrying on and going on. Now, this other side, there is a court case, you know, which is happening. So this also puts the judges in jeopardy. Now, you imagine, a government has been formed, cabinet has been appointed, things are working on, maybe, you know, the president has made some executive orders here and there and stuff like that. Then there's a court, actually, that is challenging his election. The Ugandan case is different, that when we go to court, we put everything on pause until court pronounces itself. You can't get to a scenario where you say, okay, we elected the other day on the 16th of January, President Museveni has declared winner, maybe on the 20th, he's sworn in as president. Then again, a month later, then you say, no, we've come back to realize that you actually not validly elected. So we cancelling the election. Let's get back into the business. It's different. That's why Tanzania decided otherwise. Tanzania's law is very clear. It says that once the Electoral Commission declares a winner, then nobody can actually go to court. I think it was in 2010 when somebody, one lawyer in Tanzania took, he petitioned actually the court, for the constitutional court, to just say we are disenfranchised as, you know, we are disenfranchised as Tanzanians, and it's a human right that if we get into an election and I feel disgruntled, I feel aggrieved, I need to find a way of actually settling my grievances and all these things. So you can't tell me we're going to an election and you don't allow me to go to court to challenge the process.
Which unfortunately also did not see the light of that day, but I think in civil democracy,
yes, of course,
that should be very, very important.
It didn't see the light of the day, so that's why it works different in Tanzania. In Tanzania, it's done. We used to call it in football, I think, the sudden death goal. The sudden death goal, once you fail to score in 90 minutes and you go into the extra time, it was sudden death. You score the ball, once you get the ball, then the game gets done. You don't have to wait for all the time to elapse.
Well, the reason why you first looked at the African continent, reason being is sometimes in any judgment, precedence is important, but also people should know that some of these circumstances are totally different. Like we told you about Ghana, I was impressed when I was reading about Ghana that even a government is already in power. When we talk about what happened in Malawi, you said there are different terms under same. Come to Kenya, still different times. For them, there was a period where even you wouldn't access the courts of law because of the violence that was there. Jagena, now we return back home to Uganda. 4 times we've had them. People have gone to court. At one time, they said you've produced evidence. I think that was Besige, yes, it was Besige, where the judges agreed that, yes, there were irregularities, but they are not sufficient enough to cause nullification of a presidential election.
That's what the legal fraternity keeps juggling about with the substantiality clause. How substantial is it that it can actually nullify an election? Now the substantiality, a bit of it. But I think from what you asked, yes, it is relevant and significant that we have these presidential petitions. Now this is the 4th in our history. In 1980, when we had that election that everybody talks about, the chairperson of the Electoral Commission at that time was called Ezekiel Chikira. People don't remember Chikira so much. They actually remember, I think, Vincent Sekono, who was the secretary of the commission. But the chairperson of the commission, the Byabakama, or the Badiru Chigundu of that time was actually called Ezekiel Chikira. Now, Ezekiel Chikira's powers were sapped by Paulo Mwanga of the Uganda People's Congress. And he issued the legal notice number 10 of 1980. Now, the legal notice number 10 of 1980 had 2 very important things in it. Number 1, it usurped the powers of the Electoral Commission chairperson, and it was him now to declare who the winner of the election was. Number 2, it also took all the authority of the courts to adjudicate in any electoral disputes. That was also in that particular legal notice number 10 of 1980. That the legal notice said nobody should even actually go to court. Now there was no avenue. There was totally no avenue of anybody going to court. And there were quite a number of disputes over different people who decided to go to court. Now, some of these were actually even UPC themselves, even when it was UPC doing it in favor of Dr. Apollo Milton Obote. But there were even UPC people who also are finding ways to run to court. I think Sebirumbi was one of them who decided to run to court.
But he was a chairman of UPC in Uganda.
Exactly. Now, but you see, the legal notice of Paulo Mwanga of 1980, number 10 of 1980, he usurped all these powers of the Electoral Commission and the adjudicators, which is now the courts. Nobody should actually seek legal redress to manage these electoral disputes. Now, that was not there. Now, when you come over the time, you get that when you look at the 1995 Constitution, the way in which it was written and formed, it didn't very much look at these scenarios. That's why when you look at Article 104 of the Constitution that says you can actually go to court, it was very unrealistic that it says in 7 days, in 30 days, you have to redo the process. You need to gather the evidences. Then, of course, court pronounces itself. Then, if court nullifies an election, then you redo it in 20 days. Now, that was overly being very optimistic about the process because they never looked at that. Unrealistic in one way. Unrealistic in a way, yes. Overly unrealistic and optimistic in a way. That there are certain things that they didn't consider because we were coming from a history, a background that you remember that we've had 8 presidents. We've had 8 persons as presidents of Uganda. Now, of all these 8 heads of state, 7 have actually become presidents by overthrowing a sitting government.
The power of the barrow.
Exactly, by overthrowing a sitting government. The only government that we had where there was not that was the government of Walter Coates, when Walter Coates, Governor Walter Coates was actually giving power to Mutesa. Now, from when Walter Coates gave it to Mutesa and subsequently coming on. So, the 1995 Constitution was wow, that it paved the way for an election of adult suffrage where Ugandans actually would choose and vote for their own leader. And they said, we need to have that. When you actually read the Commission of Inquiry, not the Constitutional Commission of Odochi, it has very good things in there that over time maybe Ugandans have actually not gotten into and stuff like that. So, but you see, when you look at them, when you come to 1996, when you had that election, which of course went smoothly and without many of these issues, but of course we also started reconsidering. Remember, when you look at the electoral rolls of this country, the Presidential Elections Act, the Electoral Commissions Act itself, when you look at the Parliamentary Elections Act, and the others, and of course the Constitution also, you look at them that they actually hadn't put a lot of effort on or really studied what happens in case we nullify an election. Now, the first presidential petition that we had in 2001 gave its own recommendations. We had another which also gave similar recommendations. Now you could look at both scenarios, the 2001 case, the 2006 case, also coming up with particular, and in any case, similar recommendations. That were not implemented or put into a place much later. Now, when you look at the Amama Mbabazi case of 2006, the courts pronounced themselves. Actually, the ruling was issued on the 26th of August 2016. And now they had 10 recommendations in that particular Amama Mbabazi case. Now, the 10 particular recommendations that they had an issue of discussion today, because they helped a lot in now facilitating for this particular case of Chagulanyi. Exactly. So the significance here is it's very important that as we build our democracies, then we're also having legal precedents upon which we can look at and say, here is what we have. Now, these court rulings also help us, even when they do not nullify an election, to actually say you are not validly elected. But what they do to us is they help us to restructure. They help us to reform. They help us to rewrite our electoral laws. And we now need to get very conscious and say...
At that agenda, yes, this has been there. But have we had the political will in ensuring these recommendations in this specific ruling are put to? I'll take an example as we're approaching elections. Members of parliament were very clear that, hey, we are going for an election, but we have A, B, C that we've not looked at, and these are areas of interest. Is there a political will, or have we left them for study purposes, like we are, and also discussion, having papers done on them? Because basically the laws pronounce themselves on some of these recommendations to be implemented.
Political will, some lady was discussing political will in one of the summits of the EU, and we're talking about corruption, and she described political will as political will is political can, it's political want, and it's political who. Now, political can means, can we, first of all, get there? Is that the willingness? Can we actually possibly have this done? Then the political want, do we even want to do this? Now, when you talk about political will, then there has also to be the political want. Do we want to do what we want to do? Then, when you talk about political will, you talk about political who. Who should do
these
this?
recommendations favoring?
Can we?
The who?
Can we? Do we want to? Who is going to do it? Now, when you talk about political will, yes, because you notice that the Amama Mbabazi case of 2016, the courts were very clear. The courts made 3 orders. Number 1, the first order was ordering the Attorney General to implement the recommendations within 2 years, together with the other stakeholders, the legislature and the executive. Number 2, to submit that report actually to courts, to submit the report to courts. And number 3, of course, the courts to again see what further more recommendations they can give about that. But that came from the different recommendations, and court was very astute on their recommendations. Number 1, they said, when we look at the previous 2 petitions of 2001 and 2006, these things are actually similar. They talked about, as number 1, they talked about the time to, first of all, redo the election. And they said the time that we have in our constitution, even when it was talked about in 2001, it is the same thing that was talked about in 2002, rather 2006. Now it's the same thing that came out in this particular ruling again of the Amama Mbabazi in 2016. And they all agreed unanimously that it is not realistic. It is not practical that we can actually do these elections. Why? Because they looked at why they think the time is not enough. Because if you accuse, they said, the previous rulings and this particular ruling of 2016 all found that the Electoral Commission had some wanting issues in them. Now, there are challenges in there, especially challenges of procuring election materials, getting funding, and quite a number of things. Now, if you have a whole 5 years, for example, to organize. Now, this particular electoral process was launched on the 10th of December 2018. It moved on up to, I think it's actually ending today for the few.
Well,
yes, exactly, for the residual places that didn't have this. Now, but from that time, if you have funding challenges and funding gaps, if you have procurement issues, remember that we were talking about procuring ballot papers, who
printed
does them,
here,
printed there, printed there, the expenses and stuff like that.
Yes.
Exactly, quite a number of things. Now, if you have all those challenges in there and you say we are nullifying an election, then nullifying an election means you have to redo other processes. So you have to again get back to the national voter, because the electoral cycle is actually, it has so many components in there. The voter registrations you need to do to restructure again, find the demarcations of the electoral areas or the
it's due the same process over.
It's due the same process. So and they agreed that yes, if we decided to redo this thing in 20 days, would it be possible that we do it now? Courts did not actually say don't do it in 20 days, but do it in so many days. The recommendation was, the court was very astute on that, and they said we recommend that more time should be thought about. Now, courts didn't actually put a time limit of figures and say it shouldn't be 20, it should be 30 or 40 or 50 or 100 or 120 days.
So that was left with Parliament and others.
It was left to, exactly, the Attorney General actually to work together with the executive and the legislature to find that time. Then the other thing that they talked about was the kind of evidence, the affidavit evidence, as you talk about the evidences here with Mpima Chibirango a while ago. So they were also talking about the evidence bit of it. Now, the affidavit evidence, a court said it is also not desirable in this particular, in such cases, because firstly, they are partisan evidences that when you swear an affidavit, you're swearing an affidavit as a member of that political party. You go and swear an affidavit, I, Jagenda Semakula, a member of the Uganda People's Congress, I am an adult, I am swearing, this is my name, this is my you know, then you are swearing an affidavit which is partisan because you are giving your party position. Now, you can't, actually, the courts were very clear and say we cannot cross-examine. We cannot cross-examine the affidavits. So, but with leave of court, we need in the future to actually find oral. We need to find oral witnesses where you can give court chance to actually ask a question, or even the parties, the parties also cross-examine your
witnesses that are produced.
The witnesses, yes, exactly, because these are the issues. Now, why people should actually appreciate many of these things is that even when court does not say, let's redo the election, but he also provides for some of these things and know that, okay, going forward, I think this will be better. And steadily, we're actually building it. For example, you'll notice that the time to actually file and here the case was very limited. In the 2001 case, 2006 case, even when Amama Mbabazi went, you remember very well that Amama Mbabazi's lawyer, Severino Tunobusinje, actually was running out of time, and we possibly all thought maybe nobody would even go to court. But on the D-Day itself is when we saw him come up very late, I think just about an hour to the end of the day, to be in there. He was struggling to find all this. And the issues there were, you're talking about a constituency which is a national constituency. You're talking about, in this case, for example, 34,684 polling stations in 146 districts of Uganda. So marshalling and getting everything that you need from all these places is actually not...
Actually, after the judgment, Severino was very clear. He said that we would have won this case. But time given to us was the problem.
Now, the Honorable Chagulanyi actually benefits from that. Severino Tunobusinje and his team, the Council members and the others, didn't have that time.
It's time to collect enough evidence that can lead to an annulment of an election.
Exactly. Now, from that ruling or from that particular court case where people want to say it's just a waste of time, it's not a waste of time, because today, Council Wameri, Council Segona, Council Lukwago, Council Abdallah Chwanuka, and all the others who are representing the Honorable Chagulanyi Center and the National Interplatform have time that Severino Tunobusinje did not have. So they are benefiting from the case that Severino Tunobusinje actually took to court on behalf of Amama Mbabazi. So that's the importance about it, because had it stayed from where Dr. Kizza Besigye had actually left it, and there was no ruling for the 2016 election, then we wouldn't even be talking about a presidential election petition at this time. It should have been a closed chapter. We would be moving on to...
because of time, Jagana, also something, of course, the hearing has not begun, still more of serving. Let's look at one question that many Ugandans are asking themselves. Can Uganda's court do what Kenya did, what Malawi did?
They shouldn't do it. Well, now that's a very outright question. To say yes they can or no they can.
On behalf of our viewers,
yes,
that is something very... Can the independence of the judiciary in such matters? That is the question in the minds of many Ugandans.
The judiciary is independent, but independent of who? You know, that also disturbs a lot of people, the independence of separation of powers. You know, the Montesquieu.
That's why when it rules in my favor, it has been excellent. We congratulate the judges. But when it rules in the other way, it is not independent.
No, the independence is actually, sorry, the judiciary is independent. But you see, this happens everywhere. Now, I am yet to find or read constitutions on the continent of Africa where the judges come from the Wananchi. They are not elected as we elect politicians. Even if it wasn't President Museveni today as president, and it's maybe Dr. Kizza Besigye or Abedi Wanika or even Honorable Chagulanyi, the constitution is very clear on who appoints judges. That's very clear. Who appoints judges? So you can't say, well, these are Museveni courts, these are Museveni's courts, and these are Museveni's judges. So they can't. First of all, it's actually demeaning their integrity and their intellect and whatever that means. And like you said, when the courts rule in your favor, then they are independent. When they rule in another person's favor, then they are not independent. So we shouldn't judge courts' independence by what they actually give to us. But what you're talking about is, can the courts in Uganda do that? Yes, they can. depending on, number one, the evidences that have been adduced, because that's what the law does. The law does not do things just out of emotions. And remember, you are...
Of course, Jagena, for any case, evidence is produced.
That's what
for any case, even if there is evidence produced.
Yes.
But seeing through this evidence...
Yes, exactly.
...is the issue that now we should factor in.
Yes, exactly. But you see, it's evidence, but what evidence? Do you have enough evidence to actually win a case? All of us have gone to court before and produced evidence which we actually think and know that this is evidence that is going to help me. But in courts, there is no stalemate. You can't say to draw. Like in a soccer game, you score 3 goals, I come from behind, I also score 3 goals, then we share the spoils.
So just reminding me of a friend of mine who is a lawyer, that is Sovia. Sovia told me that, you see, Robert, sometimes I had a case with, and he told me, better settle that out of court. I told him, I have my evidence. Let's go, I'll win, I'll get my compensation. He told me sometimes it is not who brings better evidence or who is right, but it's he who has a smarter team when it comes to presenting these facts before the judges.
Exactly. Now, for example, you actually even showed the pictures here of my very good mentors, Professor Locho Otieno Lumumba of the PLO Foundation in Kenya, who was representing Uhuru Kenyatta in that election petition. Now, you will notice that Counsel Rengo and his team that were representing the NASA team in courts, when Justice Maraga actually announced the election, they were all everywhere in Kenya, you know, jubilating, and you know, it became an issue to them. But at the end of the day, it actually became a sour pill for them to swallow. You know, then they go to now the realities. Because when the court said yes, because I think they only had 4 issues to settle in court. And court looked at all the 4 issues and were in their favor. And they said, we've determined this and this and this. How do you transmit these things and stuff like that? Now, then of course, court said, redo the election. Then they got to an issue of saying now, okay, courts have said the other election was annulled. There was nobody validly elected. So we got back to square one. Now, who is going to organize the election? Now, the courts had actually not said anything about the IEBC. Courts had not said that now when you do the election, this time it shouldn't be Wafula Chebukati, the EC chairperson. It should be now another person. Now still the constitution is here, and the constitution tells very clearly how do you get this, how do you get that, how do you manage this. That's why when Raila Odinga thought he was the only one supposed to contest against Uhuru Kenyatta, he decided to bow out of the elections.
Because it was a redo.
But you see, it wasn't
a rerun, it was a redo.
And that's what, that's because you see... Now,
and when they are, so that also depends on what you file.
That was also not even in the minds of Kenyans. Because when you redo the election, for example, if they cancelled, if they nullified Museveni's win today, and they say redo the election, so the question is, do I, Jagenda Semakula, also qualify to go to electoral commission and say, if Katumba was in this election, and Mayambala, and Peter Mwesigi, and Nancy Kademinanga, Basinga, can I come in and say, I'm also going to contest?
Yes, you can.
That's what we're saying.
You can, because we do.
Exactly. Yes. That's what we're saying. So, if the electoral commission did not manage to do a process seamlessly of 11 candidates, what about if today we came 20, and all of us want to contest, and we also still come back? Now, if one of the issues there in where we flouted the SOPs of COVID-19 and stuff like that, now COVID is still with us. There is no vaccine today. We just launched a drug yesterday, and we're not we're not yet doing it out. So then what happens? The electoral commission will be here. Except, and in any case, well, if courts recommend and say it shouldn't be Justice Byabakama, of course courts cannot choose for us the chairperson of the electoral commission. Again, we go back to the appointing authority to choose somebody else. Exactly. In one of the recommendations, of the Amama Mbabazi case of 2016, the judges in there said, we need to be mindful when we talk about when we nullify or when there is a nullification of an election, we also need to be mindful of managing the period. I think not nullification. Yes, doing the ruling, the time actually. They'll talk about the time to nullify an election. And so we also need to be very mindful about, we need to mind about the swearing in of the next president. Now, it means you need to decide all that before the president is actually sworn in. So if he decided to nullify the election today, then it means the president who is still here until the 12th of May, even when you recommend and say we need to find a new chairperson of the electoral commission, now there is
still
exactly
the same
the courts will not change the constitution to say the president, who still has a term until May 12th, should not be able to appoint. So the president can actually choose to say, if it's not Byabakama, then I'm appointing Patrick Ratoro. Then still it will be the president also is going to participate.
And also in these recommendations, many have been reading through these petitions and recommendations. They don't give court final authority to dictate. Most of them, court places the outcomes after the recommendations. The executive still has powers. Parliament, the Attorney General. At the end of the day, I was asking myself, but if court could come out and say, okay, Electoral Commission anew will take over this, but most of these things, they're throwing them back to a parliament. They're throwing this back to the executive, the sitting president already, to still take on. So to me, at the end of the day, I look at for fear of mentioning the word, but maybe this is my opinion, this is my view, that I look at this as court not being the final determinant of the aftermath of a ruling.
Court has 3 laws. Court has about, not 3 laws. Now, court has the constitution that is supreme. Court has the Presidential Elections, Act. Court has the Electoral Commissions Act. In this particular case, those 2 laws. Then, of course, court has what they call the case law, the precedents from the other judgments and all the things. Now, court is very clear. When you go to court, first and foremost, the Evidence Act, I think, talks about, I think, in article, in section 1 or some, I think 101 or 102 there. It says whoever comes to court, he who comes to court should actually adduce evidence to prove. You have to prove your own case. So the courts, you don't have to waste courts' time. And you see, the courts don't have that discretion of actually saying, we are nullifying the election. But as we nullify the election, we are also appointing the chairperson of the local.
That's why I say that apart from
no, but they don't have that.
The nullification, the rest still, to me, you end up looking at circumstances not changing so much. Whereas most of the people that go to court think it will all end with a nullification. That after nullification, maybe we are opening our lives to a new day. But actually what happens that so many factors, even if it was to be nullified, remain constant.
Yeah, but you see...
And which court has no mandate to dictate over them.
And that's why the courts are very clear. When they're recommending, they send it back to the Attorney General. And they tell the Attorney General, please, these are the recommendations that we're putting into place. But work with the other stakeholders, the legislature, and the executive to actually implement these things. Now remember, at the end of the day, it is the legislature that needs to come up and do the things. You remember when we talk about the constitutional amendment of the Toji Article? In the Toji Article, there were other things, and one of these things were actually the mind of Magezi. Rafael Magezi was very clear and told you, people, we are running out of time, because they were asking questions of why are you bringing Toji Article issues now? And Magezi was telling people, we went to court in 2016, and the court did its ruling in August 2016, and we given two years to actually make to implement these recommendations. Now, when Magezi came to court, Magezi was only trying to beat and to manage the time that court had actually given to see how these things are implemented. Now, why it became a Magezi? Because remember, why the courts actually have to send it back to the executive and the legislature, it is because the executive is in charge of bringing this business to Parliament. That's why whenever the President is speaking to us at every opening of session of Parliament during State of the Nation addresses, he actually tells the Speaker that we plan to bring maybe 40 or 50 bills to Parliament for this particular session. We plan to bring these. Now, it's an executive business. Now, Magezi only saw that the Attorney General, Biaruhanga, was not coming forth to actually bring these things. Then he comes as a private member to say, there is a court case and a court ruling. There is actually a court ruling, and it requests for the following recommendations. So here is where we are. Now, we all preoccupied our minds with Article 102B of the Constitution of the Toji Article, but there were also the other things. Now the increment of the time in here was one of those, and quite a number of issues. So when you go back and actually read the Toji Article amendment, it caters for all these things. But remember, it is Parliament at the end of the day that has to sit. The judiciary cannot do what they cannot do that. Why they actually push it back to the executive is because they expect this should be executive business, that it should be the Minister of Justice or the Attorney General all the others, the Solicitor General. It's government business to actually come to court and say, we are bringing this business to the House, we need to amend this, we need to do this, we need to do this. Then, of course, a Parliament debates, Parliament discusses, Parliament does all the things, then they close it. Then eventually, it gets back to the to the judiciary. If there is any dispute, then you still have to go back to, if there is something that needs interpretation, then that's how you go back to court and say, we are requesting for interpretation of this particular law, this particular case, whatever that is. But number two, the judiciary has been very astute on its recommendations. When you look at them and when you read them, they've been so astute on them, especially in trying to inform and to reform the electoral laws. So what needs to be done is we need to get back to our electoral laws. Now that is again Parliament business. That the judiciary is actually there to wait for you. Judiciary is there to wait for you to actually come and they arbitrate.
It's what they will implement and follow.
Exactly.
Well, Jagna, time is not on our best side. We must come to an end of this program for many others also to continue. But before we conclude, as we look at your final remarks regarding these electoral petitions that we've been discussing on the continent of Africa, back home in Uganda, we must also understand that for any judgment, they must also be politically awake of the situation, that as they pass their judgment, they must factor in the political outcomes. I want us to conclude with that.
Yes, that's very important. I think all judges need to have that political consciousness in them when they're doing these judgments. There is what they normally refer to as a Solomonic judgment of King Solomon in the Bible. You have to be very conscious and say, okay, you have two contending parties here, you do not know what will happen. She says the baby is hers, she also says the baby is hers, and here is the baby. Now everyone says the dead one is not mine, the living one is mine.
So
yes, let's split the baby, and every one of you takes half of the baby. So when the other said, please let's do that, then logically you can't surrender your baby and give a piece of your baby to some other person. You would rather. So I think when the judges are doing what they're doing, they need to be very very conscious politically to actually know that if we did this, how does it benefit the country? Does this help us go forward, or this will actually disorganize the country? But by and large, to me, I'm happy that by deciding to go to court, you have decided not to be violent. If you decide not to go to court, then it means you are now taking on the violence path. But once you decide to go to court, then it means you have actually refused the violence path.
And may I end with this, that when you go to court, the ruling of the court legitimizes whatever took you to court. For example, when you go to court, it is a constitutional right. When you go to court, just for formality, and not knowing that you have evidence, when court rules that that election was free and fair and you did not get success, in one way or the other, you've legitimized the leadership of your opponent.
But even then, not going to court also legitimizes. In 2011, Kiza Besje, Dr. Wanika, and everybody decided not to go to court. Now, when the time elapses for you to go to court and you do not go, so even not going to court also legitimizes. So both ways. When you choose not to go to court, you make it legitimate. When you go to court,
I don't know if because here it is clear that okay, done and dusted, you lost an election, even court did that. But if I don't go, maybe I could.
Nobody's still it legitimizes.
Anyway, we have to come to the end of this program. Have a lovely day. God bless you. God bless Motherland Uganda.
Live from UBC Studios in Kampala, this is Good Morning Uganda Extra.